You're watching The Legal Breakdown. Glenn, all eyes right now are on this federal case in the Southern District of New York where the Trump administration is trying to get the judge, Judge Ho, to dismiss the federal charges against Eric Adams. We now have a decision by the judge. Can you explain what just happened?
Yeah, the decision by Judge Ho is I need a heck of a lot more information and I need an adversarial party before I will even begin to decide whether Donald Trump's Department of Justice should be able to dismiss Eric Adams' public corruption case. So let's unravel that. Just within the last day or two, there was a hearing held by Judge Ho because Donald Trump's, one of his attack dogs, I would even call him a henchman at the Department of Justice, a former criminal defense attorney for Donald Trump, a guy named Emil Bove, who presently is the acting number 2 person at the Department of Justice, filed a motion to dismiss Eric Adams' case. Not because it was deficient on the evidence or the law, but because they wanted Eric Adams to be able to help Donald Trump with some of his political priorities, like working on an immigration task force. So that, first and foremost, is an improper reason to try to dismiss the criminal case of a defendant. So Judge Ho said, let's have a hearing. Come on in. Tell me what your reasons are for wanting to dismiss the case. And interestingly, Brian, when the reporting came out of the courtroom, people were like, well, Judge Ho didn't seem all that critical. He wasn't asking pointed or searing or difficult questions. He was just letting Emil Bove say whatever he wanted unchallenged. To which I said to myself, that feels like Judge Ho just kind of setting things up for the future. And that is what we learned today. So what did Judge Ho do? He issued an order saying, among other things, there's no adversarial party here because the prosecutor and the defendant, Mayor Eric Adams, are on the same page. Everybody wants to dismiss a significant public corruption prosecution against the mayor of New York City, and everybody wants to go home happy. Well, it's not surprising Mayor Adams wants the case dismissed,
right,
but it is staggering that the Department of Justice would want to dismiss a significant public corruption case.
And so that's what I was thinking is like you have both of these parties here. You have the prosecutor and the defendant who both want this case dismissed. And so what grounds does Judge Ho have to say, like, how can he be the unilateral arbiter if both parties want this case dismissed?
That's the perfect question and the perfect setup, because if we look at Judge Ho's order that just came out, he said, look, our judgments, meaning the judgments of courts having to make these weighty decisions, our judgments and precedents and the proper administration of the criminal law cannot be left merely to the stipulation of the parties. What does he mean by that? He means that if both parties are lockstep, there's no adversarial positions being taken,
right,
well, then, frankly, that's a decision that probably may not be as trustworthy and reliable as if two parties are fighting it out and the judge has to make the decision. And in fact, Judge Ho went on to say that in order to help clarify these positions and to have adversarial testing of the prosecution's position, I'm going to need some help. What form does that help take? Judge Ho appointed what's called an amicus curiae. What does that mean? Loosely translated, it's a friend of the court. It's somebody who can come in and give the adversarial position. For example, why shouldn't the prosecutor be allowed to dismiss? I maintain this is a corrupt quid pro quo dismissal, but why shouldn't the prosecution be allowed to dismiss a criminal case because it can act to the political advantage of the prosecutor or his boss? To which I say, that is a damn good question, Judge Ho. So Judge Ho wants somebody to take up that position in court, brief it, and if need be, argue it. And he said he'll decide it by about mid-March. It's on a very quick timetable. And the person he appointed is, I don't know if I should be surprised. I don't know if I should be heartened or displeased. It's a gentleman named Paul Clement. Who is Paul Clement? Well, first and foremost, he was the Solicitor General for the United States He's argued more than 100 Supreme Court cases. He was the Solicitor General in the George W. Bush administration. But when you read his biography, he has argued conservative position after conservative position after conservative position, against the Affordable Care Act, for example. And I'll let people read up on Paul Clement's background for themselves. So some may say, well, if you have a radical right-wing, criminal practitioner, will that necessarily serve this issue well? I don't know. I'm going to completely set ideology aside because, this is somebody with some real criminal justice bona fides, even if he is a conservative-leaning former Solicitor General, who I think will come in and probably give Judge Ho, the exact straight story on the importance of, for example, the integrity of the Department of Justice. So a Department of Justice should not be in the business of prosecuting people, but then promising to dismiss the charges if they can get something of political advantage out of those defendants. I don't care if you are left, right, and center in your political leanings or your ideology. That is anathema, if I'm using that word correctly, to the proper functioning of the criminal justice system. And I have a feeling that's exactly what the amicus curiae, the friend of the court who's just been appointed, Paul Clement, will deliver to Judge Ho.
If Paul Clement was appointed, does that mean that he's bound to some degree to argue the opposite of what the DOJ and Eric Adams are arguing? Because it doesn't seem like it would serve the purpose very well if this guy is just going to be politically aligned with the Trump administration and basically argue the same thing that the DOJ is arguing. So reason would have it that he would expressly be on the opposite end of this issue. And so is there some assurance that he is going to be on the other end of this issue?
Yeah, what a great question. One would think that the whole notion of an adversarial process
is that they would be adversarial.
Bingo. I mean, if you've got Donald Trump's corrupt DOJ and a corrupt New York mayor on the same team, which that is what's happening right now, don't you need an adversary? Don't you need another team to meet the challenge? Here's what I'll say about that. I believe that an amicus curiae, a friend of the court who enters the case at the judge's request, has to give the judge his best or her best estimation of the state of the law, of the equities of the matter, of the institutional principles, challenges, and possible danger to the integrity of institutions if you have the prosecutor and the defense attorney figuratively getting in bed together for political advantage. So I don't think the fact that Paul Clement has been appointed to take on this adversarial task means that he must reach a particular conclusion. I think it really will be wide open for Paul Clement to say, listen, this is how I assess it. And if I were the adversary, these are the legitimate arguments I would offer. However, stay with me here, it's down in the weeds of criminal law and criminal procedure. You have a responsibility as a party to a case to also acknowledge contrary precedent. So if there's something that Paul Clements would argue as an adversarial advocate, but who also has to acknowledge, well, but there is precedent out there that allows this sort of thing to be done, that sanctions it, that suggests it's not an improper dismissal or a dirty quid pro quo, I, even though I'm taking up an adversarial position, have to acknowledge it and then discuss the implications of it. The reality is, I think most legal scholars would say you can't engage in this kind of a quid pro quo dismissal. So even though I think Paul Clement will be unconstrained and be able to offer whatever his best legal judgment is, it's going to end up being an adversarial position to the position that Trump's henchmen and Mayor Adams took together to try to get rid of this case.
So just to clarify here, is there a world in which you have basically the prosecutors and the defendants teaming up together, and you can have a friend of the court come in and become the de facto prosecutor that if Judge Ho finds that what he's saying is valid, is legitimate enough, this case will move forward with a friend of the court, with Paul Clement, arguing against Eric Adams, and this case will continue. And Eric Adams is basically bolstered by the DOJ, who's initially prosecuting him.
Yeah, it's a great question, Brian. And I'm going to be honest, I don't know that there is any lawful or procedural vehicle for Judge Ho to say, for example, I'm persuaded by Paul Clement's arguments that this case should not be dismissed in the way DOJ has tried to dismiss it. I don't know that there's a procedural vehicle for Judge Ho to take the next step and say, I am thereby appointing a special prosecutor myself. There used to be an independent counsel law that involved a lot of judicial involvement in independent counsel, independent prosecutors. That law lapsed long ago and it was never renewed. And then we sort of adopted this special prosecutor procedure, but that's completely under the command and control, really, ultimately, of the Department of Justice, the Attorney General, and therefore the President. So I'm not sure that there is a procedural ability for Judge Ho to do that. But here's the thing. One of the cases that Judge Ho cited as authority in this brand new order appointing this friend of the court, Paul Clement, was the Mike Flynn case. Because let's go back a few years to earlier Trump corruption during his first administration when he tried to do a favor, though, for his friend Mike Flynn, who had been indicted for repeatedly lying to the FBI. And Judge Emmett Sullivan, who presided over that case, it seems he was looking for a way not to dismiss the Mike Flynn case. When the Department of Justice wanted to dismiss it, he appointed a friend of the court, an amicus curiae, and that person did a whole survey of the law and ended up basically saying, well, Judge, it doesn't seem you have a lot of wiggle room on this one, even taking the adversarial position because, Trump's DOJ and Mike Flynn were lockstep. They wanted to get rid of that case. So, I don't know how this will resolve itself, but I do not want to give our viewers false hope that there might be some vehicle to have an independent prosecutor, gallop in and successfully take up the prosecution of Mayor Adams. I think that is very unlikely.
If it's unlikely, why would Judge Ho begin the process in the first place? If it's not certain that there can actually be some resolution if he does find Paul Clement's arguments persuasive, then why even engage in this whole experiment? Why not just grant the DOJ what they're asking for?
Two reasons. Because under Rule 48 of the Rules of Federal Criminal Procedure, a judge must determine whether this dismissal violates the public's interest. So it doesn't mean that there may be some ultimate remedy where justice wins the day, but that doesn't mean the judge can just throw up his hands and say, you know what, I'm not even going to go down the path of trying to figure out if this motion to dismiss is contrary to the public interest of the people of New York and the people of the United States, because by the rules, I have to make that decision before I act on the motion to dismiss. And Brian, there's value in the fight. The fight is more important than the result. Let me just add that when I was supervising 30 federal homicide prosecutors, I always told them it's more important to try righteous cases than it is to win guilty verdicts in cases, because it's all about the fight. And as long as you're fighting by the rules, the law, and the Constitution, you let the result sort itself out. If you decline to fight because you don't think you can win at the end of the day, then we have all already lost.
Yeah, I find that a little interesting that the judge is bound by a rule that prevents him or her from being able to just dismiss things outright without first taking this step. But then what I find conspicuously absent in all of this is an enforcement mechanism if indeed the judge does find that the case was corruptly dropped.
Yeah, Brian, but let me take that up. Let's kind of pull on that thread a little bit more. First of all, I believe the rules contemplate that if a judge refuses to allow the prosecution to nefariously or corruptly dismiss a criminal case, finding it is absolutely contrary to the public interest, I think the desired effect there is that an honest, honorable, because you can have disagreements over these things, particularly as between co-equal branches of government, the executive branch, the DOJ, and the judicial branch, the federal judge. What I think our laws and our procedures envision is that maybe the executive branch, after being on the receiving end of that kind of a devastating ruling by a judge, would take a step back and say, we have absorbed what the federal court said after this adversarial hearing, and we are withdrawing our motion to dismiss.
Right.
We're going to proceed with this case.
Of course, that would require some degree of integrity.
It would require integrity, and we have to acknowledge that separate branches of government only have but so much power. So the judge can make this ruling, but the judge can't then direct the prosecution of the case. That is up to the goodwill, the honor, the integrity, and the allegiance to the Constitution of the people in Donald Trump's Department of Justice. So I will ask, where does that leave us?
Right. All of which is in short supply these days. Well, look, this is a very interesting case working itself out quite quickly here, so we'll stay on top of it. For those who are watching, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. That's also the best way to support our work and to support independent media more broadly, which has become more and more important as we're watching legacy media, mainstream media continue to drop the ball. So I'll put the links to our channels right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.